Now let's talk about consummation of sale. Let's say the seller and the buyer entered into a contract of sale of a cow. Here, the seller has the obligation to preserve the subject matter, or the cow, before delivery. Also, if the cow bears an offspring before delivery, then the seller also has the obligation to deliver the offspring together with the cow, which is the subject matter of the sale. In sales, delivery or tradition refers to the concurrent transfer of two things, possession and ownership. Thus, absence of an agreement that ownership is retained by the seller until the buyer has fully paid the price, delivery or tradition produces its natural legal effects, most important of which being conveyance of ownership, without prejudice to the right of the seller to claim the payment of price. The failure of the buyer to pay the price does not cause the ownership to revest to the seller unless the contract of sale is first rescinded. Delivery may be actual or constructive. An example of constructive delivery is the execution of the notarized deed of sale of a parcel of land, which is a public instrument. So notwithstanding the presence of illegal occupants on the subject property, the transfer of ownership by constructive delivery can still be effected through the execution of the deed of sale. The buyer, as the owner, has several options. Among these, she could file ejectment suits against the occupants, or she could amicably secure the latter's evacuation of the premises. Whatever mode the buyer chooses, it signifies her control and her intention as owner to obtain for herself and to terminate said occupant's actual possession thereof. However, when from the face of the instrument it is shown that the seller was not yet the owner of the property, such as the seller was only expecting to inherit it from her father, the execution of the notarized deed of sale cannot be considered a constructive delivery. Now let's talk about double sales of immovable property. Let's say the vendor sells a parcel of land to two vendees. Who has the better right? Here, the one who has the better right is the first registrant in good faith. Should there be no entry, the first in possession of the subject property in good faith, and in the absence thereof, the buyer who presents the oldest title in good faith has the better right. A purchaser in good faith is one who buys property without notice that some other person has a right to or interest in such property, and pays a full and fair price for the same at the time of such purchase, or before he has notice of claim or interest of some other person in the property. So when the buyer has not yet fully paid the purchase price, and as long as the seller remains unpaid, the buyer cannot feign good faith. One of the instances when there is no good faith is when a real estate corporation's agent knew that there are occupants other than the seller in the subject property, but no investigation was made. It is a well-settled rule that a purchaser cannot close his eyes to facts which should put a reasonable man upon his guard, and then claim that he acted in good faith under the belief that there was no defect in the title of the vendor. Also, the sale to one's daughter and son will give rise to the conclusion that the buyers, not being really third parties, knew of the previous sale and cannot be considered in good faith. The buyers are deemed to have constructive knowledge by virtue of their relationship to the seller. Note also that the buyer of a registered land would be in bad faith when he purchases without asking to see the owner's copy of title and/or without visiting the subject parcel of land. Now let's proceed with the obligations of the buyer. The buyer must pay the price, but when the seller cannot show title to the subject matter, then he cannot compel the buyer to pay the price. Note that unless the parties have agreed otherwise, payment to be effective must be made to the person in whose favor the obligation has been constituted, or his successor in interest, or any person authorized to receive it. Note also that since delivery of the subject matter is an obligation on the part of the seller, the acceptance thereof by the buyer is not a condition for the completeness of delivery. So that's it for our review on consummation of sale. Thank you for listening.